From California to New York, from Amsterdam to the Caribbean, from Kansas City to Washington, D.C., in courtrooms, in classrooms, in conference rooms, and in webinars. Every day people gather at ABI events to hear the best ideas bubbling up in their communities. Today, you are a part of a global conversation about our shared future. So, what is this ABI Talks? ABI Talks is an initiative of the ABI Board of Directors Education Committee, a committee devoted to creating the best and most exciting bankruptcy education possible. The committee plans and organizes this conference and the annual spring meeting in Washington, D.C., and helps set policy for regional conferences. This event today is based on the TED Talks format and ideals, but is independently organized by the ABI. So please be sure to thank the team of volunteers and ABI staff members who worked so hard on today's event. It is their ideas, dedication, and time that makes this all possible. The views you hear today are, of course, the views of those speakers, not necessarily of the ABI. We hope their talks spark an exciting conversation among you. It is a day for curiosity and skepticism, for openness and for critical thinking, for inspiration and for action. The more you enter into it, the more you will take out. And now, on with the show.
Good morning again. I have the pleasure of being your Master of Ceremonies for today's ABI Talks program. Today you will experience some of the best ideas and lessons bubbling up from the bankruptcy community, all presented by 5 of your fellow ABI members. Our program, of course, is based on TED Talks. TED is an acronym for Technology, Entertainment, and Design, and these are the fields of experience around which the first TED was conducted in 1984. Since then, the TED program has become a globally recognized format. The ABI Talks program, of course, is younger, started in Terranea a few years ago, and that format has been copied at numerous regional conferences. Our speakers were selected today because of their special expertise in areas that we thought might be of interest to you. As we have in the past, we selected 2 programs from recent regional conferences. We were so impressed, we wanted to share these presentations with a national program audience. The remaining 3 are brand new. One important note on the format: unlike many of our other formats, we would appreciate that if questions percolate during today's presentations, you hold it until after the program. Our speakers will gladly meet with you in the hallway after the presentation. And now, on to the show. I've had the pleasure of introducing our 4th speaker several times lately. He's a well-known bankruptcy judge from Wilmington, Delaware. Before that, he was in Philadelphia. He is involved in numerous mega cases and written numerous important decisions. But I am most jealous of what he was asked to do at the NCBJ in 2017. He got to interview my favorite author, Michael Lewis. Ladies and gentlemen, ABI Talks is proud to present Judge Kevin Carey.
Thank you, Doug. Good evening, everyone. Yes, good evening. Come on, say it back. I had a long day in court today, so I thought I'd take a little bit of time and share some of the thoughts I had about some of the hearings that went on in my courtroom today. So let's begin. Learn how to take yes for an answer. What do I mean by that? Well, I had an oral argument, and the way I approach oral arguments is I go to the side that I think has the better, stronger argument, and I press to convince myself that based on what I read in the papers, it really is the stronger, better argument. I do the same thing with the side that I think has the weaker argument, press that to make sure it's as weak as I initially thought it was. So during the argument, I'm talking to the side that I think has the better argument, and the lawyer's going through his points. And he gets to a point, and I say, I totally agree with that. The lawyer continues to argue the point. Wait, take yes for an answer. I agree with you, move on. And frankly, if I'd done the same with the other side, and I say, look, counselor, that's not your strongest argument. You might want to spend more time talking about other parts of, stop, move on, get the message. Learn to take yes for an answer. Next slide. Don't insult the judge. I always prepare for my hearings, and I do it myself. I typically don't staff it out. The hearing binder is in my office. I get my own self ready normally for a hearing. So I had an argument today in a long-standing dispute. The government's chasing some hedge funds for unpaid capital gains taxes that the government says it should have. So the government lawyer starts out by saying, Your Honor, have you read our submissions? Now, I know this case is going to go to the district court on appeal no matter who wins or loses, and I feel like he's setting a trap. So if I answer, no, I didn't read the things, they can point to the district court and say, hey, the judge was just unprepared. I looked at the lawyer and I said, look, the next time I come to the bench unprepared will be the first time. I was insulted. Turns out the government won anyway. Know your judge. Now, that doesn't mean you have to know my favorite vacation spot or my favorite island bar, which happens to be on Joost van Dyke in the British Virgin Islands. But I digress. In the early 2000s, I had my very first major valuation fight. It was in the first Exide case. And the professionals, as professionals do, had to teach me all about valuation. I wrote this opinion that I've been told by a Harvard Business School professor and a finance professor at Wharton that they use to teach their students valuation. It's actually in the text I use when I teach law school. Now, why do I tell you this? It's not to say it's any great scholarly work, but it goes through all the very basic stuff, including the glossary of terms. So, at a hearing today, a lawyer starts to examine his expert, and he says, please explain to the court what EBITDA is. Please explain to Judge Carey what a discount rate is. What's the weighted average cost of capital? Please tell the judge about beta and about the CAPM pricing model. I said to the lawyer, look, I wrote an opinion years ago. I know this stuff. If you want to tell me that beta should be company-specific rather than industry-specific like the other expert says, yeah, spend some time talking about that. Don't tell me stuff I already know. Know your judge. Before you walk in the courtroom, know what the judge knows and what he probably doesn't know, so you can help him get to decide that you're right. An expert witness who answers the question asked on cross-examination the first time gets to go home sooner. At a hearing today, expert witness on cross-examination, lawyers hammering away, expert witness doesn't answer the question, but repeats what he said on direct as many times as he can. Look, I know what's going on. The witness is afraid the lawyer's trying to set a trap, and he probably is. But I understand what's going on. I know what's happening. Right after I said that, the expert witness actually answered the question directly. I said, now, wasn't that easier? It's so much easier when you do that, and it keeps my attention better. If I look like that, you know there's a problem. Had a hearing today in which there was a very long examination. And after about 20 minutes, I looked down at my notepad. There was nothing on it. So I said to the lawyer, this line of questioning you're pursuing now isn't very helpful to me. You might want to move on to the next topic. So what do you do if I look like that? Well, change your tone, change your pace, and if you're a male over 50, you probably need a comfort break anyway. anything to keep me fresh. Okay. So many lawyers are very concerned about making the record. Had a hearing today. Bench was full of exhibit binders. Now, hundreds of exhibits. How many of those are actually going to be relevant? How many will actually be referred to? How many will I actually use in coming to a decision? Very few. What I did find helpful, though, was the lawyer gave me an exhibit binder for each witness, so that the number of documents I looked at was limited to those which the witness was discussing. That was very helpful. But what you want is me to be zeroed in on the important facts, on the important law. Don't scatter your case in such a way that you're thinking, well, if I go up on appeal, I want to be able to say, I got this into the record. Worry about what I'm going to do. It's not the task of an adverse witness to make your case. Had a hearing today. Lawyers cross-examining an adverse witness, asking the same question over and over again. Finally, the witness's counsel stands up and says, Your Honor, question was asked and answered, I object. Well, counselor, it was asked, but it wasn't answered. So I'm going to let opposing counsel ask that question until your witness actually answers it. Sat down, witness answered the question. But it sometimes doesn't really serve a point, whether the witness is answering the question or not, to continue hammering the witness. It's not useful for me. It doesn't help me get to the end. And you know what? There is almost never that Perry Mason moment. Yes, it was me. I killed Colonel Mustard in the library with a lead pipe. It never happens. Okay, next slide. There's almost always a business solution to every dispute. What do I mean by that? Had a case today. It was an argument on a creditor's motion to dismiss. What had happened? Well, just before the bankruptcy, there had been a series of forbearance agreements which the debtor had been forced to enter into. Nothing new, right? Pretty standard. The last forbearance provided that the lender was granted a small ownership interest in the company. The forbearance agreement also provided that the debtor had to change its corporate documents to provide that it could not file an 11 unless there was unanimity among the owners of the company. So what happened? Debtor filed anyway. Lender comes running in, motion to dismiss. Debtor's not authorized to file. Other grounds. I decide for federal public policy purposes that that agreement wasn't enforceable. But I'm thinking this is a long fight ahead. I pulled the parties into chambers. I said to the debtor, tell me what you want. Your Honor, we want more time to refinance that debt. I turned to the lender, I said, what do you want? We want the asset. Well, think about this. How about if we give the debtor the exclusive period, 120 days, to get refinanced? And if the debtor can't do that, I'll grant the motion to dismiss or I'll grant relief from the stay. I'll do whatever it is you want so you can get the asset. Debtor says, that's great, it's got 120 free days, love it. Lender says, well, look, what if the debtor files a motion to extend the exclusive period? How do I know you're not going to grant it? Because I told you I'm not going to, and I'm telling the debtor now I'm not going to. Turns out, debtor couldn't get refinanced, case gets dismissed, lender gets the asset. What's the point? The point is, there's a business solution to almost every dispute. Now, from a judge's standpoint, it's difficult. Sometimes you don't know how active to be in pushing the parties to a certain place where they can make an agreement. But even if the judge doesn't press, even after the bankruptcy filing, even with all the emotions, you should try to find the business solution. There's almost always one there. Don't ignore bad facts or tough law. At a hearing today, It's an issue I'd never encountered, and it was a legal proposition that the circuit had never talked about. But one side had another circuit court opinion that was directly on point. And they argued the case, of course. The other side didn't address the case in its papers or really in its argument. And I turned to that side and said, what about this? And they basically said, look, tell me it's not binding, tell me it's not persuasive, tell me that you know about it, and here's why it doesn't apply here, but don't ignore it. It's going to kill your credibility, and it doesn't help me get to say yes to what you want me to say yes to. Now here's something I really love. There's a lawyer who appears in front of me routinely, and he was in court today. He's got this uncanny ability to know when I have a question. And sometimes I think he actually knows I have a question before I know I have a question. But what does he do? He watches my eyes, he watches my facial expression, my body language. He has a script, and he follows his script, but he keeps his eye on me at the same time. And he'll pause sometimes, even when I may not have a question. He says, does Your Honor have any questions so far? That's amazingly effective. I love it. It helps me, it keeps me engaged, and it helps him. Your client is paying you a lot of money to tell its story. Had a hearing today. I knew the client was in the courtroom because I'd seen this party before. The lawyer told the client's story by the pleadings she filed, the arguments she made, the questions she asked on examination, the objections she made during examination, her confidence. And I know that win, lose, or draw, that matter, the client's going to go home knowing that his story was told in a way that the judge heard it and understood it. Be clear, concise, and you'll win a lot of the time. And even if you don't, your client will be happy. So that's all I have to share with you. Thank you very much. It's time for my Irish whiskey.
Thanks, Judge. Thank you, Judge Carey.